application wakatidza dhara haadi kuti zvione iye dhara havanafanira kuti ubvise dhara.
The voice or the audio may be, or of the presiding officer may be recorded.
Maar de stem of wat die voorzitter de ambte gezet, dan dat kan opgenomen zet.
Then how kuti anotaura kuti vanongobvisa izvozvo dhara achitaura vanongobvisa hapana problem.
And finally, this application shall stand until the finality of this bail application in this court. I don't know, we are depending on the state, but next time there shall be no application made by the media in this court. That's if this court will be sitting in this bail application.
Verder, die media zal hier opnames nemen, slechts in hierdie hof wat ons die bordaansoek hanteer. Dat zal net gebeuren in die hofzaal.
Then mozo chikumbiro chebheri chamopinda mukoti iyoyi hapasina chikumbiro chinounzwa futi hapasina imwe application yakaitwa yapera. Then koti ndiyo ichagara ichinzwe kuti chikumbiro chebheri chinofamba sei mukoti iyoyi.
I believe my order is clear. Thank you.
Thank you.
As it pleases the court, please.
As it pleases the court.
Yes.
Thank you, Worship. Therefore,
The accused may remain seated.
Beskuldigdes bly maar net zittend.
State Court, the matter, case number CP 38 of 2024, State versus Zakaria, and two others. Today's proceedings are as follows. Today is the 2nd of October 2024. The court is constituted as follows. Presiding officer, Ms. F. Ntilani. State prosecutor, Advocate El Mashiani. With me, my worship is Advocate Kukune. The interpreter, we have got Mr. Khadidze and Mr. Siakamela. The stenographer, we have got Ms. Siaga. The court orderly, we have warrant officer Levelo. The defense for accused number 1, we've got Mr. Rieder. For number 2, we've got Advocate Mohammed. And for number 3, we have Ms. Brown. Your Worship, the matter is today on the roll for the bail application in respect of the accused before this court. However, before we even go to the applications itself, I should think Ms. Brown will need to address the court at this stage, Your Worship. Thank you.
Die saak is voor vanaf voorloof dat die bordaansoek moet gedoen word ten opsigte van beskuldigdes. Maar voor ons kan voortgaan, het is procureer wat terwijl ook u hof iets zegt, is ten opzichte van beskuldigde nummer 3.
Then Saturday and very and I would Loyanga Sumirira. Veteranga Sumiranda and it's Kumbir Pabri Tari.
Good morning, Your Worship.
Good morning.
C. Brown appearing on behalf of accused number 3 in this matter, Your Worship. Your Worship, I would like to inform the court that I will be withdrawing as a legal representative for accused number 3 here in Your Worship due to a lack of financial instructions, Your Worship. Your Worship, that's also my role, if I may be excused.
Ik verstem namens beskuldigde nummer 3, maar ik wil die aansoek recht voorloof dat ik wil hê dat ik niet verder gaan om beskuldigde nummer 3 te procureur te wees nie. Dit is volgens dat finansies instructies niet gedoen word. So as ek nou sal vra dat die hof wil mee dat ek toe terecht ben.
Maar je wil soms dat je
Do you confirm?
Then,
Ms. Brown is withdrawn.
urukunzwisa xikumbira ka taura ari kuti anda kuti abve pamosoyo nekuti hapana mari akatobhadhara kana urukunzwisa uri kutendera nazvo ata kupindura nemuromo.
Yes.
Correct, your worship. I agree.
Now that Ms. Brown has applied to withdraw his attorney of record, the application by Ms. Brown to withdraw is granted. Now at choice number 3, you have the right to be legally represented by an attorney of your own choice at your own expense if you have money. However, if you don't have money or you cannot afford the services of your own legal representative, you have the right to apply for legal aid. In order for Legal Aid South Africa to assist you with an attorney free of charge, you won't pay money for legal aid services. They will represent you to the best of their abilities, or you may conduct your own defense. However, looking at the seriousness of the offenses that you are charged with, it is recommended that you must have a legal representative. If you don't have money, you may apply for legal aid. Do you understand, sir? If yes, what do you elect to do?
Then, zvisisa chikumbiro chakahunza dhura vedhara kakumirira dhara anotendera nacho kuti ari kutobuda pamusoro ari kubvisa pamusoro. Saka izvozvo ivo vakamirira havana lawyer. Saka handa kuziva kuti kana usina kumirirwa nemunhu une first ndeyekuti unokwanisa kutsvaga mumwe kana une mari uye nelawyer ukatera naye. Kana usina mari yacho utarise pamusoro wakakura sei. Musoro wakakura wombe musoro. Musoro wakakura stere. Kana usina mari pane Legal Aid South Africa vanokumirira free of charge mahara haubhadhari chinhu. Kana usingadi ku lawyer unomubhadhara, kana usina legal aid unokwanisa kuzvimirira. But uchida kuzvimirira fungudzisa kuti mhosva wakakura, mhosva wombe urukunzvisa uchaita sei. Understand also?
Yes, what do you elect to do?
Saka izvozvo uda kuita sei? Yes, state. All right. Then, Your Worship, I will elect to be represented by the legal aid state attorney.
And Ms. Brown, your application to withdraw as attorney of record is hereby granted.
Thank you, Worship. If I may be
You
excused.
are excused.
Thank you, Worship.
Yes, Mr. Father.
Thank you, Your Worship. Your Worship, if I may, I have had a discussion with accused number 3, Your Worship, and my office has undertaken to assist him pro bono if he so wishes, Your Worship. Same was discussed with him, with the interpreter present, Your Worship. He seemed to have agreed. I'm not sure if there's a change in his instruction. If you would so wish to proceed with legal aid, Your Worship, if the clerk can just seek clarity from the accused.
Thank you. Sir, I am now addressed by Mr. Barrow that his office is willing to assist you pro bono.
Right.
That it's still going to give you the services like legal aid to pay money
That would-
for his services. I just want to know that are you going to proceed with legal aid or are you going to proceed with Mr. Barrow?
Manje, zvisa izvozvo nhasi mukuseri ndakauya naye akataura kuti vanokumirira iwe wabvisa anokumirira munhu anomupa mari nevabereki beuyu akagara ngati. Ndakauya nini pasi ndichiri kutsamurira kuti no vanoda kukumirira nekuti uya achiti iye asikumirira nekuti amada kupiwa mari, uyu anoda kukumirira free mahara. Iwewo watichi wateni izvozvo wati uda estate kana uda kuti vakumirire. Handiti ndiye akati no ndinokumirira vabereki ndivo vanokupa mari. Uda iye kana uda kuenda kuwaya welegal aid. All right, Bishop. I will continue with Mr.
Thank you. Mr. Farah, you are placing yourself on record.
That is correct, Your Worship. I will.
Now you are going to represent both and choose number 2 and number 3.
That is indeed correct, so Your Worship.
Thank you, may you be seated, sir.
Dit is inderdaad zo dat ik nu bevestig ik gaan verschillen ten opzichte van teskeligte 2 en 3.
Thank you, Worship. As I indicated earlier, the matter was placed on the road today for the bail application in respect of the three accused before this court. However, Your Worship, by all indications is that the counsel for the accused are not ready to proceed with the bail application. First of all, there is some pending issue that is the subject of appeal in this matter, which has not been resolved. And already my learned friend for accused number 1 had indicated that he is not proceeding with the bail application before that issue is resolved. And I have further engaged with counsel for 2 and 3, and he also indicated the same, that he is of the view that the bail issue needs to be resolved before the bail application is proceeded with. I must indicate, Your Worship, that as far as the state is concerned, the pending issue is only affecting applicant number 1 in this court, and I find no reason how that impact on the application that is to be brought by number 2 and number 3. However, I'm in the hands of the applicants, Your Worship, if they are of the view that it's not in their interest or in the interest of their clients that they proceed with the application, I have no issue with that. I must just place it on record that nobody gets confused, Your Worship, that the state is ready to proceed with the bail application in respect of all the applicants before this court. And if the court so orders that we proceed with the bail application, we are available and ready.
Is dat die hoofmeet dat hulle is gereed om voortgaan met die borgaansoek van die saak was op die rol voor die rol van die geplaas ter borgaansoek doeleindes. Maar die ander kant, die verdedigingssaak, onze kant, hulle het probleem daarmee, want het is iets wat hangende is. Dit is die appel wat nog steeds hangend is. Klagte nummer 1 se prokureur het gesê dat hulle het probleem om voort te gaan voordat hulle kan die uitslag kry van daai appel. En ek weet nie hoekom dit kan dit gehanteer nie, want ten opsigte van al die belastingslag wat ons voorhoof is, ons is gereed om dat die borg te doen.
Andot kumiro chakaitwa che appeal nienda bawana cheti nakatuna matri amupinzi pa appeal yacho but izos mutongis I don't know izos tiri titange mzat kumiro cheti but number 1 butera kamutaro no set tanga nekuti takamirira marizalta ya appeal appeal yakamira aisati yabudisama result saka number 2 ne number 3 panopinda sei panyoyo number 1 kana wakuti dhara ndoti ngatitange tiye kumberi nemuzati kumochobhei then chambotanga but number 1 iyanuti inini andikutanga nekuti ndakamirira appeal yakaitwa.
Having said that, Your Worship, we remain in the court's hands to give direction in the matter, and I must also indicate at this stage, even though it may seem a bit premature, we have already discussed amongst ourselves and agreed on a date for the further investigation, subject to what is to happen in this court today. Thank you.
Dan die hof sal vir ons sê wat in rigting ons vat, maar alhoewel dit is kan vroeg wees om dit te sê, maar ons het ook gereël dat ons dit moet 'n ander datum kry waar die ondersoek is gedoen, maar dit is net slegs vir ander doeleindes.
Akataura kuti no, kana kakuti dhara nokutaura kuti chii kana chii, but adu mera kunderi padhara pa kuti titange kana sei, but ane date yakawirirana ne maloya ese ari pa.
As it pleases the court, Your Worship. Your Worship, the defence have a total different view regarding the reason why this bail cannot proceed. An order was given by your brother, Magistrate Chaya, in which the defence was granted access to the docket on accused number 1. This order was appealed. Now, this appeal is suspending the whole process. And this appeal is brought by the prosecution. This process cannot move forward until the appeal has been finalized. So this is not a question that that the defense is the driver of this bus, or it's in the hands of the defense. This is the prosecution which needs to drive this bus and get things going. This bail cannot proceed until the appeal has been finalized because there's an order made. So we are, don't want to use the word held hostage, but we are held at bay pending finalization of the appeal. And that is the reason why the bail cannot proceed.
En ten opsigte van beskuldigde nommer 1, die prokureur deel hoof mee dat kyk, dit is die staat wat wil die appel genotuleer, want dit is die collega van die voorsittende beampte wat hier is, wat 'n bevel gemaak het dat beskuldigde nommer 1 moet die inhoud van die prosedure kry. Toe maak hulle die appel. Dan as dit nog hangende is, dit maak dat die stak, ons kan nie voortgaan nie, ons wag vir die uitslag van die bevel wat die appel wat hulle het genotuleer. Dit is die staat self wat die appel genotuleer.
Maar roept daar goed te zeggen. Ndiani akaunza chikumbiro choche appeal asiyo ndiye mtongisi prosecutor ndiye akaunza chikumbiro chokuti nekuti daro uko akati order iyo kuti lo apiwe ma copies docket se ndiye ani manje akaunza chikumbiro ndiye mtongisi isusu takatoita se takabatwa westage yekuti tinotanga sevheri tinotanga nekunza vheri se tisatapuwa marizalti kana apila yabuda yapedza kudecide.
Now, so this is clear in my address that the reason for the bail not proceeding is the appeal. It is not in the hands of the defense at this stage at all in any way that we are able to proceed, especially in relation to accused number 1, with the bail proceedings pending the appeal. So up until when the appeal has been finalized, the bail proceedings will then be able to proceed.
Dit is inderdaad so dat nadat die appel wel gefinaliseer is, dis die stadium toe ons kan gereed voortgaan met die aansoek. Want nou wat hangende is, dit is die uitslag wat maak ons dat ons stak.
Now, this appeal is directly related to how accused number 1 will deal with the bail proceedings. So this is not a side issue. This appeal, this order regarding the access to the docket is a direct influence and a direct aspect which needs to be addressed before accused number 1 can proceed with a bail application.
En die kwessie dat die inhoud van die dossier moet gekry word, dit is die wat wel die beskuldigde moet kry, sodat hy kan homself gereed maak, of dat hy kan homself prepare, dat hy kan die borg aansoek, want dit hang af dat wat hy kry vanaf die uitslag af.
Now, it is indeed correct that we have agreed to date at the court's pleasure, of course, and that this date is for further investigation because there cannot be a date fixed for bail pending finalization of the appeal.
Inderdaad, soos het gereël met die ander datum wat ons sal voorloop kom verskyn, maar ons het gesê dit sal verdere ondersoek doen, want ons kan nie moes die datum sê dit is vir die borg self, want ons wag nog steeds vir die uitslag van die appel.
So the reason for the postponement for further investigation is that to curb costs for my client and that we do not know when the appeal will be finalized, the matter is now postponed for further investigation and not for bail.
Dit is die rede hoekom ons sê verder ondersoek, want ons weet nie wanneer wel gaan ons die uitslag kry van die appel schrijf.
Now, and then I'm thinking I may be jumping in on my learned colleague, but I just want to add, on a previous occasion, even the state argued that they would rather have both bail applications heard at the same time than have it piecemeal.
En op vorige stadium miskien hulle sal my korrek sê indien ek is nie korrek nie. Die stad het wel gesê dat hulle wil die borg aansoek doen. Hulle wil dit op in een keer doen almal, nie dat hulle kan dit kortliks dit doen.
So that is the other reason why my colleague, and he will address the court possibly further on that point. But that was one of the reasons why we're all sitting in the same boat and rowing together.
My collega sal wel die hoof toespreek daaroor. Dit is ook die rede wat ek wil op die lig bring op 'n vorige stadium.
So as it pleases the court, I would just like to bring that to the court's attention, because if in future there is delays or postponements regarding arguments, that is the true reason behind the postponement. As it pleases the court, I don't know if there's any other aspect that I haven't addressed sufficiently. As it pleases the court.
Soos dit die hof debat, dit is die wat ek wil net op die lig bring sodat die hof sy aandag trek dat indien dit is op vorige stadium of op 'n keer dat wel sê dat ons kry of dit is die gebeur, maar die hof moet die inligting wat ek vir haar verskaf het.
Right. Daar moet ons dis is Chirutara gojara na maharutara no. Atitanga the best atapua ma outcomes kana marisata appeal. Neguti. Tunotanga say number 2 number 3. Na yokutara gatunire. Izo. Kawira na prosecutor na mtoto good no mtongisi. Tipe de tire mutsakisi motion. Tata mulira. Tunomira appeal ya chibuye. Then tatanga ne saka anda kuti dara zive kuti kana kwakuti pane delay yemhosva yokutanga kana kuti asi dara asatora zvokuti ni delay yekuti ndiye uyu number 1 kana ndiye uyu number delay chava iri papo yekuti notakamirira chete appeal kuti nobudira atisi changomirira zuva iroro richitanga kubuda appeal tinotanga nebhili.
Thank you, Your Worship. Your Worship, I'd first like to address the aspect of my learned colleague where he makes the statement of he doesn't understand as to how accused number 1 statement will not affect my client's Worship. Your Worship, if one simply looks at the charge sheet, one will note that the charges have been placed in common purpose. Your Worship, obviously the statement that the state refuses to hand over at this stage, pending the appeal, will have a detrimental effect to the bail application of both accused number 2 and 3. Your Worship, it will simply be reckless for the defense to then proceed with an application without having consulted with my learned colleague in regards to that statement. Now, Your Worship, the state makes the submission that they are not to be blamed or the delay is not on their side. However, they are in contravention of that order in which that statement had to be handed over, Your Worship. Had that not been the case, we would have proceeded today, Your Worship. However, Your Worship, we are in the hands of the court in terms of waiting for that appeal process to now be conducted. And once the outcome is granted, Your Worship, we will then duly proceed. As the court views it.
Die prokureur wat nou opgestaan het sê, nee kyk, die stad wil hê dat dit moet nie geplaneer word op hierdie geleentheid nie. Maar dit is hulle wat wil die rigtinge laat stak, want dit is hulle wat ons die appel gemaak het. Indien dit was nie so gewees het nie, ons sou nou voortgegaan het. So nou ons wag dat ons moet slegs die uitslag kry van daai appel. Dit is die probleem. Sodra ons dit kry, dan ons is gereed.
Vazi, vera utara kona. Dia na konza chikumere chokuti no anati ndinchokisi ndiye mutongi zuwe. Saka izvozvo zvokuti pane kuti mhosva rokutova usatanga une delay sei nekuti ndiwo wakaunza chikumbiro chokuti pave neapili yatakamirira iyo apili. Isusu kwakona kuti no apili havana kuapili. Apili yakatanga kuti tinotanga nebhili. Pane
Thank you, Worship. Maybe briefly in reply. My learned friend for applicant 1 indicates that on the previous occasion, state indicated that they would prefer or desire that the bail applications be had simultaneously. However, Your Worship, that cannot be a prerequisite to hearing the bail application in respect of this matter. Any one of the accused can bring bail application at own leisure. And you can say, I'm not bringing bail application in respect of number 3 because I want it heard simultaneously with applicant number 1. That cannot be. Each of my learned friends has got own instructions as to how to proceed with the matter. Now that things are a bit stuck with applicant number 1, does this mean accused 2 and 3 will never bring bail application before this court? That cannot be. Now, regarding the issue that the accused before this court are charged under common purpose, that cannot be a bar to bring in the simultaneous bail applications. We are told that it will have a detrimental effect if the appeal for number 1 is not resolved. But we are not being told how that detriment will come about. And from where I stand, Your Worship, I don't see anyhow whatever happens with accused number 1 or applicant number 1 will have a detrimental impact or effect on accused number 3, for instance. And my learned friend for number 2 as well used maybe a strong word for lack of proper words, that the state is in contravention of the very court order. That is too strong. Because if anyone is in contravention of any court order in this court, Your Worship, he gets arrested. And if that is how strong the legal representative for the accused feel, they are welcome to take that any steps. But I can't find how one can say we are in contravention of the court order and at the same time acknowledge that we are in the process of appealing that very order. These two sentences don't go together. However, Your Worship, I don't want to build a mountain out of molecule. Having said that, Your Worship, I respectfully submit that it's very clear that the bail applications will not be proceeded with today. And I therefore apply that this matter be remanded for further investigations. The date that we had agreed on is the 6th of November. And this matter shall now be referred back to MANKWENG, where it originally comes from. Should there be any application in the meantime, this court will be notified and appropriate steps will be taken. As the court, please.
Ja, kortliks ek wil net dat kyk elke een kan op 'n eie stadium 'n bord aansoek voor die hof bring. Dit kan nu sê dat ten opsigte van beskuldigde moet een van die nie bord aansoek doen dan dat maak ook beskuldigde moet 2 of 3. Elke een met sy regte, sy eie instruksie kan sy eie bord aansoek doen op sy eie stadium, op sy eie bevel of enige tyd. En dan kom ek met dat dit is inderdaad so dat ons kan nie vandag wel die bordverrigtinge voortgaan nie. Ons het gereël dat die saak moet uitgestel word vir die ander datum. Dit is in November. Dit is ons het gereël dat dit is net vir verdere ondersoek. Indien dit kan iets gebeur terwyl ons wag vir daai te doen, dan ons kan die hof op enige stadium in kennis stel wat gebeur of wat gaan aan. En die saak self sal weer teruggaan by MANKWENG waar hy is op afkomstig. Indien dat ander reëlings wat sal getref word of iets wat gaan gedoen word, ons sal hier die hof in kennis stel.
Haurambi kuti 1 kana 2 kana 3 aunze chikumbiro chake chebail auri kuti bail inofana kuti igarirwe nevanhu vese same time. mumwe nemumwe anofanira kunza chake chikumbiro but haasi kuramba kutongesa ndoti no takawirirana nekuti musi wayo udzoke futi kana uchauya musi wa6 November but uchapinda kukoti yakatotanga yekuMANKWENG hatirambi kuti no kana kwakuti pane zvinhu zvakachinja pane something new then dhara achaziviswa achamuudza dhara kuti chii chakachinja.
I know we coordinate with the defense that this matter be referred to MANKWENG, and then the date of the 6th is that they must appear in MANKWENG.
That is so.
It should not be brought to
No,
this office.
they appear in
Until,
MANKWENG.
All issues are resolved, and once the issues are resolved, you communicate amongst yourself and notify this court for the arrangement of the new date for the application.
That is so, Your Worship.
Die hof wil uitvind of van het hele kry vanaf die stadse kant. En dit is dat die sak moet terugstuur word na MANKWENG toe. Dit bedoel dat ons gaan wag totdat iets gebeur. En dit wil iets op die leg bring gekom het en die beskuldig wil die nuwe aansoek bring vir die board aansoek. Dan julle sal ons hierdie hof in kennis stel sodat die redes kan getref word. En dat so dit is wat die let it bevestig.
Ndakamira chokuti kana pakuti no zvaitwa zvachinja then mutongozi ndiye achaita sei chowirirana nelawyer yako number 1 then vachiti toda kutoisa kuuya nebail application kumbiro chacho bail takutanga but izvozvo date yatakawirirana ndeyekuti musi warikuenda kudzokera kuMANKWENG.
Which court in MANKWENG?
Court A, Your Worship.
Can you please stand up?
Your Worship, if I might, I apologize, Your Worship.
Oh.
There's just one more point which I would like to bring to the court's attention. I have canvassed it with my colleague to prosecution. My client is 60 years old. It has been brought to the court's attention in the previous appearance that my client has certain medical conditions that is not being treated by correctional services. So if the court could just also bring that to the attention to the prosecution, also note that, and maybe to the investigating officer regarding it. It has been noted apparently on the J7, but it's not being acted upon.
Okay, where is he? In prison or?
In prison. He's currently
Okay, I will make a note on the J7 to the head of the prison to attend to this. The investigating officer can just make a follow-up.
I thank the court.
Thank you.
Slechts één ding wat ik wil op die aandacht brengen. De skellig van die Moorkin is nu 60 jaar oud en zijn gezondheid is niet die een wat recht is. En hij sukkel om zijn medische of conditie na te komen. Maar het was gezegd op een vorige stadium tegen andere hof, maar het is niet nagekomen. Dan wordt het antwoord. Ik zal het op die J7 spreek dat hij moet dat doen. En ik zal ook die onderzoekambten zeggen dat hij moet dit wel voor en zien dat het is gedoe.
Thank you. This matter was set up today for bail application, However, they are proceeding today due to the fact that there is a pending decision in the High Court, which is the subject matter of one of the factors relating to this bail application. Both the parties have addressed the court on the issue of the bail not proceeding. The court cannot give any order otherwise because it is imperative that the decision of the High Court be available as indicated by the defense on behalf of the accused who are the applicants. Even though the state is ready to proceed, but the state is not the applicant in this proceeding. If the applicants are not ready, I see no reason why the court can force that the bail application proceeds. It will not be in the interest of justice, and it will be prejudicial to the persons as the applicants in this bail application to proceed with it when they know that the decision of the High Court may have an effect, an effect or impact on this bail application. Therefore, an application to postpone this matter is hereby granted, and this matter now is referred back to MANKWENG, that the accused person will appear there in MANKWENG District Court A on the 6th of November 2024 for further investigations. And the parties have assured the court that should there be any developments, this court will be notified and a new date for the bail application will be arranged for the bail application to proceed. In the circumstances, accused 1, 2, and 3 are in custody. You have no bail. Accused number 1, Mr. Red is your legal representative. Accused 2 and 3, Mr. Farouk is your legal representative. Then you will remain in custody. You will be appearing in MANKWENG District Court A on the 6th of November 2024 at 8:30. I thank you.
Nadat ek alles gehoor van beide kante, beide partye, dit is sterk dat so as kan nie voortgaan met die aansoek vandag nie, want dit is ook gesê dat die part wat die uitslag wat hulle verwag van die hoë raad, dit is iets wat wel ook deskundige help dat hulle bord aansoek doen. So vandag, hoewel die stad sy les gewees, maar het is nie hulle wat die aansoek brengt voor working. Dit is deskundige. So deskundige het nie alles wat hulle wil hê voorbeeld dat hulle kan ons voortgaan. So die staat sal nodig uitkom tot die 6 November, maar dit sal nie hier wees nie. Ek gaan terug na MANKWENG toe. Deskundige sal net in heftenis wees tot daai betrokke dag. Indien dat iets wat op die dat kan op die gang kom, dan sal ons die hierop inleg, dan die nieuwe datum gereël word vir die nieuwe paar aansoek.
Sibonga ukuthi izos. Diana anumza sikumele chebhele yiwo. Saka iwo izozi uchimira kuti ndakumirira apili yachiuya, ndakumirira zvese zvazokuti High Court vaunze apili ya. Mutongisi ane mapowers ekuti no ndakwenda kumberi kana iwe semunhu anokumbira bail usati wava ready. Iwe unofana kuti se izvozvi nekuti ndawana zvese ndereveti ndendobva chikumberi. Saka gara achikuramba kuti mosvauya musa 6 November, but amuuyi muno, muchauya muno kana zvinhu zvakatogadzira. But izvozvi 6 November muri kuenda kuCourt A MANKWENG 2024 1. Saka kutanga nhasi kuenda kumberi, munhu anokumirira Mr. Farouk. Roses ndiye gota razvo.
We truly appreciate your accommodating us today, and may I just suggest that this court briefly attends. I don't see this court being cleared without.
Yeah. It's true, but just one aspect in respect of, I need the J7 so that I can endorse the accused number 1 be attended to by the head of the prison, but the investigating officer will make a follow-up in that aspect.
I will sort that.
Yeah, they just need to know with regard to this charge sheet, shall it remain here?
I've
And
already
then-
spoken to my
Because
colleague
I
to
would
attend
not
to
to endorse on the J15 that it reflected. If we're still going to use the best structure, then I think when you decide on it, I don't want to endorse on the J15. But
My colleague will attend to
Will
it.
attend
If
to
there's a need,
Ah.
I think he will approach you for the necessary endorsement.
One last aspect to all the parties. I can see that the language that has been used for now is English, Shona. Is it Shona, sir?
Correct, Your Worship.
All right, and Afrikaans. What about the other members of the community, the cottagers until the